In the spring of 1855, the Grass Valley Telegraph published a brief notice about complaints lodged with the Nevada County Sheriff. The article mentioned a boarding house along the main wagon route near Rough and Ready, California. What the newspaper described as disturbances at a miner's lodging establishment concealed a transaction that would expose the darkest possibilities of frontier marriage. Before we dive into the story, click the like button and subscribe to the channel so you never miss these spine-chilling revelations. And after you've subscribed, write in the comments where you're watching from and what brought you here today. Whether this finds you during your morning routine, afternoon break, or late-night deep dive, you're joining thousands of brave souls who choose to face the darkness of our past together. Now, let's continue with the story. The mining settlement of Rough and Ready kept no official census in 1855. Established during the gold rush's frenzied early years, the community existed as a loose collection of claims, tents, and rough timber structures strung along the wagon route between Grass Valley and Nevada City. Men arrived daily, chasing rumors of new strikes. Most departed just as quickly, leaving behind only debts and disappointment. Silas Kephardt's boarding house stood at the eastern edge of the settlement, where the road narrowed before climbing into the pine-covered hills. The structure itself was unremarkable, a single-story building with a stone chimney and a covered porch facing the rutted thoroughfare. A painted sign advertised lodging for travelers at 50 cents per night, meals included. In a region where most miners slept in canvas shelters or crowded bunkhouses, even basic accommodations attracted steady business. Silas had arrived from Pennsylvania in 1851 with his young wife Eleanor and dreams of striking a profitable claim. The reality of California mining crushed those ambitions within months. His claim near the Yuba River yielded barely enough gold dust to cover supplies. By 1852, mounting debt forced him to abandon prospecting entirely. The boarding house represented his pivot from mining to servicing the constant stream of travelers moving through the diggings. Eleanor managed the domestic operations. She prepared meals, washed linens, and maintained the rough comfort that kept customers returning. Travelers remarked on her youth and quiet efficiency. She rarely spoke beyond what hospitality required, moving through her duties with the practiced reserve of someone who had learned to make herself small in the presence of strangers. But something about the Kephardt establishment troubled certain guests. Conversations occurred in low voices after Eleanor retired for the evening. Silas would approach particular travelers, men journeying alone, and suggest additional arrangements beyond simple lodging. The nature of these offers remained unspoken in polite company, yet word spread along the wagon routes with the peculiar speed that scandalous information travels in isolated communities. By May of 1855, 3 separate complaints had reached Sheriff Edmund Rowe's office in Nevada City. The complainants described practices at the Kephardt boarding house that violated community standards, though the specific language of their affidavits remained carefully vague. The sheriff recognized the delicacy of the situation. Frontier California maintained complex, often contradictory attitudes about vice, morality, and the sanctity of marriage. What a man did within his own household, with his own wife, occupied uncertain legal territory. The documents preserved in Nevada County archives reveal Sheriff Rowe's hesitation. He delayed action for 3 weeks, perhaps hoping the matter would resolve itself or that the complainants would withdraw their concerns. But the complaints continued, growing more specific and more disturbing with each new testimony. Eleanor Drayton had been 18 years old when she married Silas Kephardt in Pittsburgh during the winter of 1851. Her father, a foundryman, who had died in a workplace accident the previous autumn, left behind only debts. Her mother had passed years earlier from consumption. Without family or resources, Eleanor faced the limited options available to young women in her position: domestic service, factory work, or marriage. Silas presented himself as a man of prospects. 10 years her senior, he spoke confidently about California's opportunities, showing her newspaper advertisements promising fortunes in the goldfields. He had secured passage on a wagon train departing that spring. Marriage to him meant escape from Pittsburgh's industrial grimness and the possibility of a better life in the West. The reality she discovered in California bore no resemblance to Silas's promises. His mining claim produced almost nothing. Other men around them struck profitable veins, but Silas's tunnel yielded only worthless quartz and mounting frustration. He began drinking heavily, spending their meager resources on whiskey while blaming Eleanor for his failures. She learned quickly that her husband's charm evaporated under pressure, replaced by bitter anger and accusations. When Silas announced they would open a boarding house, Eleanor felt relief. Honest work seemed preferable to watching her husband destroy himself in a played-out mine. She threw herself into the labor, rising before dawn to prepare meals, scrubbing floors, washing clothes in water hauled from the creek. The work exhausted her, but guests appreciated her efforts, and the boarding house began earning steady income. Then, in the autumn of 1854, Silas made his proposal. They were clearing the table after supper when he explained his plan. A guest had expressed interest in Eleanor's company, he said, using language that made his meaning unmistakable. The man would pay $5, more than they earned from a week of regular lodging. Silas presented the arrangement as temporary necessity, something to get them through the winter until business improved. He spoke as though describing any other commercial transaction. Eleanor refused. The argument that followed lasted through the night. Silas invoked their marriage vows, her duty as a wife, the debt they owed to creditors. He reminded her that she owned nothing, had nowhere to go, possessed no legal standing independent of him. California law recognized wives as their husband's property in all but name. If she refused him, he could simply abandon her, leaving her destitute in a mining camp hundreds of miles from civilization. The first time happened 3 nights later. Silas accepted payment from a freight hauler passing through to Sacramento. He gave Eleanor no choice in the matter, treating her objections as irrelevant to what he considered his right as her husband. She endured in silence, her mind retreating to some distant place, while her body remained trapped in the physical transaction. The freight hauler left at dawn. Silas counted the money carefully, already planning how they would spend it. The arrangement continued through the winter. Not every guest participated, some men reacting with disgust when Silas made his offer. But enough accepted. The mining camps attracted men who had left conventional society behind, who viewed frontier California as a place where normal rules was dissolved. Silas developed a practiced approach for identifying likely customers, reading something in their manner that suggested receptiveness. Eleanor stopped protesting. Resistance only provoked Silas's anger without changing the outcome. She performed her domestic duties mechanically during the day and endured the nights. The other wives in Rough and Ready, the few who remained in that predominantly male settlement, began avoiding her. Whether they knew the specifics or simply sensed something shameful about the Keefhart household, they kept their distance. By spring of 1855, Eleanor had been trapped in this existence for 6 months. She had tried once to approach a merchant about sending a letter east, but he had refused to assist her without Silas's permission. Every avenue of escape seemed closed. The settlement's isolation, her complete lack of resources, and the legal framework that granted Silas absolute authority over her life created a cage with invisible but impassable bars. The first affidavit reached Sheriff Rowe's desk on May 4, 1855. Thomas Griesby, a wagon driver hauling supplies between Sacramento and the northern mines, provided sworn testimony about his encounter at the Keefhart boarding house 3 weeks earlier. Griesby's statement, preserved in Nevada County court records, described arriving at the establishment near sunset after a long day on muddy spring roads. Eleanor served him supper while Silas chatted amiably about conditions in the diggings. After the meal, as Griesby prepared to retire to the common sleeping room, Silas drew him aside with an unusual proposition. According to the affidavit, Silas explained that for an additional $5, Griesby could enjoy Eleanor's company in private for the evening. He spoke casually, as though offering an extra blanket or a bottle of whiskey. When Griesby expressed confusion, Silas clarified his meaning explicitly. His wife was available, he said, and the transaction would be handled with complete discretion. Griesby claimed he refused immediately and departed the premises despite the late hour. But what disturbed him enough to file a formal complaint was not simply the offer itself. Frontier mining camps contained no shortage of vice. What haunted Griesby, according to his testimony, was Eleanor's expression when Silas made the proposal. She had been visible through the doorway, washing dishes at the basin. Her face revealed nothing, but Griesby swore he witnessed something worse than distress in her absolute lack of reaction, a blankness that suggested the offer was routine. The second affidavit arrived May 9th. Cornelius Sutherland, a mining equipment salesman from San Francisco, described a similar encounter. His statement added disturbing details about Silas's business practices. According to Sutherland, Silas maintained a careful assessment of potential customers, approaching only men traveling alone who appeared to have ready cash. He framed the arrangement as mutual benefit, suggesting that Eleanor enjoyed the company and that the transaction helped a struggling young couple survive California's harsh economic realities. Sutherland also refused, but unlike Griesby, he confronted Silas directly about the morality of selling access to his own wife. Silas's response, documented in the affidavit, revealed his justification. He claimed his marriage gave him authority over Eleanor's labor in all its forms. She worked in the kitchen and the laundry, he argued, so why should other forms of work be different? California law supported his position. Wives had no independent legal existence, no right to refuse their husbands' decisions about how they earned income. The third testimony proved most damaging. Dr. Isaiah Fenton, a physician traveling to a mining camp to treat a typhoid outbreak, stayed at the Kephart establishment in late April. His affidavit included medical observations that elevated the complaint beyond moral outrage into evidence of physical harm. Fenton stated that while Silas made his usual proposition, the doctor noticed bruising on Eleanor's wrists and what appeared to be finger marks on her upper arms. When he asked Eleanor directly about her well-being, she insisted she was fine, but her hands trembled as she spoke. Fenton's professional assessment, stated bluntly in legal language, was that Eleanor Kephart showed signs of sustained physical, coercion, and psychological distress consistent with prolonged mistreatment. More significantly, Fenton's affidavit named 2 other guests he encountered at the boarding house who admitted participating in Silas's arrangement. One, a prospector named Vincent Hardesty, had drunkenly boasted about the transaction. The other, whose name Fenton could not recall, had defended the practice as acceptable given Eleanor's status as Silas's wife. These 3 documents forced Sheriff Rowe's hand. The complaints came from respectable witnesses whose testimony could not be easily dismissed. Fenton's medical observations provided concrete evidence of harm. Most critically, the affidavits revealed that Silas's activities were not isolated incidents, but an ongoing commercial operation that multiple men knew about, and some had participated in. On May 12th, Sheriff Rowe rode to Rough and Ready with 2 deputies. The legal grounds for intervention remained unclear. California statutes provided no specific prohibition against a husband profiting from his wife's labor, regardless of its nature. But the accumulating testimony suggested something that even frontier California's permissive attitudes toward vice could not entirely tolerate. When Sheriff Rowe arrived at the Keephart boarding house on May 12th, he spoke with Eleanor alone, while his deputies kept Silas occupied outside. The conversation lasted less than 10 minutes. No transcript exists of what was said, but Rowe's incident report, filed that evening in Nevada City, contained a single devastating sentence about the exchange. Mrs. Keephart declined to make any statement regarding the allegations. Her silence was not mysterious. It was strategic survival within a legal system that offered her no protection and multiple punishments for speaking against her husband. Under California law in 1855, married women could not testify against their spouses in court. This restriction, inherited from English common law, assumed that wives lacked independent judgment and would either lie to protect their husbands or be coerced into false testimony against them. The law considered the marital bond so fundamental that it superseded a woman's individual obligation to truth. Even if Eleanor had been willing to testify, her words would have carried no legal weight. Courts routinely dismissed wives' complaints about husbands as domestic matters beyond judicial authority. A husband's right to his wife's obedience, labor, and body was considered sacred. Only in cases of extreme physical violence resulting in permanent injury or death might authorities consider intervening, and even then, prosecution remained rare. Beyond legal barriers stood economic reality. Eleanor owned nothing. The clothes she wore, the bed she slept in, even the food she ate, belonged legally to Silas. If she left him, she would be destitute, in a region where women's employment opportunities consisted almost entirely of domestic, service, laundry work, or prostitution. The wages for such labor barely covered survival, assuming she could find work without a husband's permission or recommendation. Divorce presented no viable solution. California required legislative approval for divorce petitions, a process so expensive and complicated that only the wealthy could pursue it. Even if Eleanor somehow navigated that process, she would need to prove extreme cruelty, a legal standard that focused on physical violence rather than sexual exploitation. Moreover, divorced women faced social stigma that made securing respectable employment nearly impossible. The cultural context surrounding marriage in 1855 California created additional constraints. Religious doctrine emphasized wives' absolute submission to husbands. Popular literature portrayed wifely obedience as the foundation of social order. Women who challenged their husband's authority were characterized as dangerous, immoral, or insane. The few women's rights activists arguing for legal reforms were dismissed as radicals threatening civilization itself. Letters preserved in the California Historical Society archives from this period reveal how thoroughly these attitudes permeated even sympathetic observers. A missionary working in the mining camps wrote in 1854 about encountering women trapped in brutal marriages. Her compassion was genuine, yet she ultimately counseled these women to pray for their husband's reformation rather than seek separation. The concept that a woman might have rights independent of her husband's wishes remained almost unthinkable to most Americans. Eleanor's situation contained another dimension that further isolated her. The nature of what Silas forced her to do carried profound shame in Victorian American culture. Women who engaged in sexual activity outside narrowly defined marital bounds were considered ruined, regardless of whether they participated willingly. If Eleanor spoke publicly about what Silas had done, she would be marked as a fallen woman, her reputation destroyed as thoroughly as if she had chosen prostitution voluntarily. This social reality created a trap within a trap. The very evidence that might have convicted Silas would simultaneously condemn Eleanor in the eyes of respectable society. Even sympathetic observers would view her with suspicion and disgust. The women who might otherwise have offered shelter or assistance would refuse to associate with someone tainted by sexual impropriety. So Eleanor remained silent when Sheriff Rowe asked his questions. She understood that speaking would likely destroy her without saving her. Rowe recognized her silence for what it was, though he lacked both the legal tools and the cultural framework to address the situation adequately. His report concluded with frustration barely concealed beneath official language. Further investigation warranted, despite lack of cooperation from alleged victim. The Pure Sheriff's next step would not involve Eleanor's testimony. It would rely instead on the men willing to speak about what they had witnessed or participated in. Rough and Ready's general store ledger, preserved in the Nevada County Historical Society, contains an entry dated March 15, 1855. Silas Kephart purchased supplies that day: flour, coffee, lamp oil, and a bottle of laudanum. The merchant, Harold Wickham, added a notation in the margin that appeared nowhere else in his meticulous records. Refused additional credit. Conscience prohibits further dealings. Wickham's private correspondence, discovered decades later among his family papers, explained that cryptic note. In a letter to his brother in Ohio, he described the Kephart situation with uncomfortable clarity. He knew what Silas was doing. Everyone in the settlement knew. The matter had become an open secret discussed in lowered voices at the saloon and the assayer's office. 3 local businessmen had attempted intervention, according to Wickham's letter. In February, they approached Silas together, hoping collective pressure might succeed where individual appeals would fail. The confrontation took place behind the livery stable, away from public view. Wickham, along with the blacksmith Luther Pembroke and assayer Douglas Thorne, told Silas directly that his treatment of Eleanor violated community standards. Silas's response demonstrated both his understanding of legal reality and his contempt for moral suasion. He asked the men to identify which law he was breaking. When they could not cite a specific statute, he suggested they mind their own affairs. What occurred between a man and his wife, he reminded them, was private marital business. If they objected to how he ran his boarding house, they were welcome to stop recommending it to travelers. The threat was implicit, but clear. All 3 men benefited financially from traffic through Rough and Ready. Wickham sold supplies to travelers. Pembroke shod their horses and repaired their wagons. Thorne assayed gold dust that miners brought from nearby claims. Silas could damage their businesses simply by directing customers elsewhere or spreading rumors about their reliability. In a small settlement where reputation meant survival, such power could not be dismissed. The 3 men retreated from their moral stand. Wickham's letter expressed shame about this failure, but he justified it through the same reasoning that paralyzed most intervention attempts. Without Eleanor's cooperation or complaint, they had no standing to act. If she chose to remain with her husband despite his actions, who were they to interfere? The letter's tortured logic revealed how thoroughly legal and cultural assumptions about marriage disabled even well-intentioned efforts to help. Other residents found different ways to accommodate knowledge they preferred not to possess. The settlement's sole restaurant owner began offering meals to Eleanor. at no charge when she appeared in town, a gesture of sympathy that required no confrontation with Silas. The minister of the small Methodist congregation preached sermons about marital duties and Christian charity without mentioning the Kiefarts by name, though everyone understood his references. Most simply avoided the boarding house entirely. Families traveling through the region received quiet warnings to seek accommodation elsewhere. Respectable miners refused to lodge there, leaving Silas's customer base increasingly composed of men whose moral standards matched his own, or who simply did not care about the circumstances behind their transaction. This selective ostracism created a perverse equilibrium. The community expressed disapproval through avoidance while leaving the fundamental situation unchanged. Eleanor remained trapped. Silas continued his business with a smaller but steady clientele. The settlement's conscience was partially salved by their informal sanctions, though these gestures did nothing to address Eleanor's actual suffering. Sheriff Rowe's investigation forced this comfortable arrangement into crisis. His inquiries made clear that passive disapproval would no longer suffice. When deputies interviewed residents, they discovered that detailed knowledge of the Kiefart operation extended far beyond the 3 men who filed formal complaints. At least a dozen people could describe Silas's practices with specificity. Several admitted they had witnessed money changing hands. Others reported conversations where Silas openly discussed his arrangement, as though describing any legitimate business venture. A few confessed they had considered reporting the matter to authorities, but assumed someone else would take responsibility. The pattern that emerged from these interviews was damning not just of Silas, but of the entire settlement. Rough and Ready had chosen collective inaction, allowing Eleanor's exploitation to continue month after month because intervention seemed too complicated, too legally ambiguous, too disruptive to their tenuous social order. Now, with formal charges pending and newspaper attention spreading beyond the immediate region, that failure could no longer be ignored. Reverend Aldous Cunningham arrived at the Kiefart boarding house on May 28, 1855, carrying letters of introduction from the Pacific Methodist Conference. His circuit included mining camps throughout Nevada County, places too small or transient to support permanent clergy. He traveled alone on horseback, spending weeks at a time moving between settlements to perform marriages, baptisms, and funerals for communities starving for religious structure. Eleanor served him supper at the common table. Cunningham noted in his journal, later donated to the Methodist Historical Society archives, that she appeared younger than he expected for a woman running a boarding establishment. Her manner struck him as carefully neutral, showing neither warmth nor coldness, simply efficient service. Silas joined them after the meal, affable and talkative as always with new guests. What happened next, according to Cunningham's detailed account, began with casual conversation. Silas asked about the minister's travels and church business. Cunningham described conditions in various camps, the hunger for spiritual guidance among men far from home and family. Then, as Silas made his proposition, with the same casual tone he had used dozens of times before, Cunningham's journal entry about that moment captured his immediate recognition. He had encountered prostitution throughout the mining regions, a reality of frontier life that troubled him, but which he addressed through preaching rather than confrontation. But Silas's offer carried a different quality. This was not a woman working independently or even under a brothel keeper's management. This was a husband selling access to his wife in their own home. The minister's response was immediate and unambiguous. He told Silas that what he described was not merely immoral, but an abomination that violated every principle of Christian marriage. Silas attempted to justify himself with the same legal arguments he had used before, claiming his authority over his wife's labor. Cunningham countered that no legal right could sanctify such exploitation, that Silas was treating Eleanor worse than Southern slaveholders treated their human property. The comparison struck deep. California had entered the Union as a free state, and many residents took fierce pride in that distinction. Silas's face darkened with anger, but Cunningham pressed his advantage. He demanded to speak with Eleanor privately. What occurred during that conversation remained between them. Cunningham's journal noted only that Eleanor confirmed the situation and that she expressed desire to escape, but saw no viable path. The minister made her an offer. He would take her to Sacramento, where Methodist charitable organizations could provide shelter and help her find legitimate employment. She would be under the church's protection. Eleanor's response revealed her accurate assessment of reality. She asked Cunningham what would happen when Silas came looking for her. The minister admitted that legally, Silas had every right to reclaim his wife. Eleanor pointed out that church protection meant nothing against a husband's legal authority. She would be returned to Silas, and her attempted escape would make her situation far worse. Cunningham could not dispute her logic, but he refused to abandon her to Silas's exploitation. If the law granted husbands such absolute power, he declared, then the law itself must be challenged. He informed Silas that he intended to report the matter to both church authorities and civil law enforcement, regardless of the legal ambiguities involved. Silas ordered the minister from his property. The confrontation nearly became physical, with Silas blocking the doorway, while Cunningham gathered his belongings. Only the presence of two other guests, minors who sided with the minister's moral position, prevented violence. They escorted Cunningham from the boarding house and accompanied him to Nevada City the following morning. The minister went directly to Sheriff Rowe's office. His testimony, combined with the earlier affidavits, provided authorities with sufficient cause to act. But more importantly, Cunningham brought institutional backing. The Methodist Conference carried significant political influence in California. A respected minister's formal complaint could not be dismissed as easily as individual travelers' objections. Cunningham's letter to church authorities, written that same day, framed the Kephart case as a test of California's commitment to Christian values. He argued that if the state's laws could not protect a wife from such treatment, then those laws required reform. The letter was published in church newsletters throughout the state, drawing attention to Eleanor's situation from religious organizations with considerable moral authority. Within days, the Sacramento Daily Union picked up the story. Other newspapers followed. What had been a local scandal became a statewide controversy about marriage, women's rights, and the limits of husbandly authority. Silas Kephart found himself facing not just legal charges, but public judgment that his previous isolation had allowed him to avoid. The trial of Silas Kephart commenced on July 9, 1855, in the Nevada County Courthouse. District Attorney Marcus Langford faced an immediate legal problem. No California statute explicitly criminalized a husband profiting from his wife's sexual labor within their marriage. After consulting with colleagues and reviewing precedents, Langford charged Silas with keeping a disorderly house, a municipal ordinance typically used against brothel operators. The charge was strategically imperfect. It avoided the unmarriageable question of husbandly authority by focusing instead on the commercial nature of Silas's operation. The prosecution would argue that the Kephart boarding house functioned as an illegal enterprise regardless of the marital relationship between Silas and Eleanor. Defense attorney James Caldwell, a Sacramento lawyer hired by Silas with borrowed funds, immediately attacked this framing. In his opening statement, He argued that the disorderly house statute applied only to establishments where multiple women engaged in prostitution. The Kifhart boarding house was a legitimate lodging operation where a married couple resided. What occurred between husband and wife in their private home could not constitute a public nuisance. The prosecution called Thomas Griesby first. His testimony matched his earlier affidavit, describing Silas's explicit proposition and Eleanor's blank expression. Under cross-examination, Caldwell pressed him on whether he had actually witnessed any illegal activity. Griesby admitted he had not, having refused the offer and departed immediately. Dr. Isaiah Fenton provided the most damaging testimony. He described the bruising he observed on Eleanor and his professional assessment of her psychological state. More critically, he testified about encountering Vincent Hardesty at the boarding house, a prospector who admitted paying Silas for Eleanor's company. Fenton's medical credentials gave his observations weight that the other witnesses lacked. Caldwell objected repeatedly, arguing that hearsay about what Hardesty allegedly said was inadmissible. Judge William Fletcher overruled him, determining that Fenton's direct observations fell within acceptable testimony. The defense attorney then attempted a different approach, suggesting that any bruising Eleanor displayed might result from normal domestic accidents rather than abuse. The prosecution's strategy avoided calling Eleanor as a witness, recognizing she could not testify against her husband and that forcing her to appear would likely backfire. Instead, Langford called Reverend Cunningham, whose moral authority and detailed account of his confrontation with Silas proved compelling to the jury. Caldwell's defense rested on two arguments. First, he claimed insufficient evidence that any illegal activity occurred, noting that most testimony consisted of Silas making offers that witnesses refused. Second, and more fundamentally, he argued that California law granted husbands broad authority over wives' labor and that nothing in the statutes distinguished between different types of work a wife might perform at her husband's direction. This second argument created visible discomfort in the courtroom. Judge Fletcher interrupted Caldwell twice, asking him to clarify whether he was truly claiming a husband could compel his wife into prostitution without legal consequence. Caldwell responded carefully, stating he made no moral judgment, but simply observed what the law permitted and prohibited. The jury, composed entirely of married men as California law required, heard closing arguments on July 12th. Langford emphasized the commercial nature of Silas's operation, the multiple witnesses who described his systematic approach to recruiting customers, and the physical evidence of harm that Dr. Fenton documented. He avoided inflammatory language about marriage or women's rights, focusing instead on public order and community standards. Caldwell countered that the prosecution had failed to prove the specific elements of keeping a disorderly house. He reminded jurors that marriage remained sacred under law, and that dangerous precedents might follow from allowing government intrusion into domestic arrangements. The jury deliberated for 1 hour and 40 minutes. Their verdict: guilty of keeping a disorderly house. The courtroom reaction was muted. Several spectators nodded approval, but others appeared troubled by the verdict's implications. Judge Fletcher scheduled sentencing for the following week, giving himself time to consider appropriate punishment for a crime that fit awkwardly within existing legal categories. Newspaper coverage of the verdict revealed California's conflicted response. The Sacramento Daily Union praised the jury for upholding community morality. The San Francisco Herald questioned whether the verdict might threaten husbands' legitimate authority over their households. Editorial writers struggled to articulate principles that would condemn Silas while preserving traditional marriage structure. Eleanor did not attend the trial. She remained at the boarding house throughout the proceedings, her absence noted, but not explained in court records. What she thought about the verdict, whether she felt relief or fear about what might follow, went unrecorded. Judge Fletcher delivered his sentence on July 19, 1855. The courtroom was less crowded than during the trial itself, the spectacle of judgment having already passed. Silas Kephart stood before the bench wearing the same clothes he had worn throughout the proceedings, his expression unreadable. Fletcher's statement revealed his struggle to balance legal precedent with moral condemnation. He began by acknowledging that the case presented unusual difficulties. California law provided limited guidance for punishing a husband's exploitation of his wife. The disorderly house statute carried maximum penalties of 6 months imprisonment and a $500 fine. But Fletcher noted these maximums were designed for professional brothel operators managing multiple women. The judge then delivered his reasoning for a reduced sentence. He stated that while Silas's actions were morally reprehensible, the defendant had no prior criminal record. The boarding house itself was not inherently illegal, and the prosecution had proven only a pattern of behavior rather than a large-scale criminal enterprise. Fletcher seemed to be searching for language that would punish Silas without creating precedents that might threaten ordinary domestic arrangements. The sentence, $200 fine and 30 days in county jail. Gasps rippled through the courtroom. Reverend Cunningham, seated in the front row, shook his head in visible disgust. The fine represented less than Silas had earned from a single month of his operation. 30 days imprisonment seemed absurdly inadequate for sustained exploitation lasting more than half a year. District Attorney Langford requested the court's permission to speak. He argued that the sentence failed to reflect the severity of the crime or provide meaningful deterrence. Fletcher responded sharply, reminding the prosecutor that he had charged Silas with a municipal violation rather than a more serious offense. If Langford believed the punishment insufficient, he should have brought different charges. The exchange exposed the prosecution's underlying weakness. No more serious charges existed that could have been proven given California's legal framework regarding marriage. Fletcher's sentence, however inadequate, represented the outer limit of what the law permitted under the charges filed. Silas paid the fine immediately with money provided by unknown supporters. He entered county jail that afternoon to begin his 30-day term. The Nevada County Sentinel reported his demeanor as confident, almost cheerful, suggesting he recognized the sentence as a victory rather than punishment. Eleanor vanished from public record the same day. No newspaper account mentioned her whereabouts. Court documents contained no information about provisions made for her support during Silas's incarceration. The boarding house remained closed, but whether Eleanor stayed there or fled elsewhere went undocumented. Reverend Cunningham's correspondence provides the only potential clue. In a letter dated July 22nd, he wrote to Methodist officials in Sacramento mentioning that he had helped the unfortunate woman reach safety, but providing no specific details. Whether this referred to Eleanor remains uncertain. Cunningham may have been deliberately vague to protect her from Silas's eventual pursuit. Census records, city directories, and county archives from the subsequent years contain no trace of Eleanor Kephart. She did not file for divorce, suggesting either she lacked resources to pursue that expensive process or feared Silas would contest it violently. Her name appeared on no employment rolls, no property records, no ship manifests, no marriage licenses under her maiden name, Drayton. Historical Society researchers in the 1960s attempted to trace her fate. They found suggestive possibilities, but nothing definitive. A woman named Ellen Drayton worked as a seamstress in San Francisco, starting in 1856. according to a business advertisement in the Alta California. Another Eleanor Kephart appeared in Oregon territorial records from 1858, though the age listed seemed wrong. A third possibility emerged from Sacramento Catholic Church records, showing a Eleanor K. receiving charity assistance in 1857 before disappearing from their rolls. None of these leads provided confirmation. Eleanor might have changed her name entirely, adopted an alias, or simply moved to a location whose records did not survive. She might have died shortly after the trial, her passing unrecorded in any official document. In Frontier, California, where record-keeping remained haphazard, and where women often existed only as appendages to male relatives, disappearing completely was easier than modern researchers find comfortable to acknowledge. What is certain is that Eleanor never returned to Rough and Ready. The boarding house remained closed throughout Silas's jail term. When he was released in mid-August, he reopened the establishment briefly before closing it permanently that autumn. Without Eleanor's domestic labor, the operation became unprofitable. The Kephart trial drew attention from territorial authorities beyond Nevada County. In September of 1855, California Attorney General Samuel Hempstead initiated a broader investigation into similar operations throughout the northern mining districts. What his investigators discovered, documented in official correspondence preserved in state archives, suggested Silas's operation was neither unique nor particularly unusual. The first comparable case emerged from Placer County. Sheriff deputies there had received complaints about a boarding house near Auburn, operated by a couple named Josiah and Margaret Finch. The pattern matched the Kephart situation with disturbing precision. Josiah offered Margaret's company to traveling miners for fees ranging from $3 to $7, depending on the customer's apparent wealth. The operation had continued for at least 8 months before authorities received formal complaints. Unlike the Kephart case, the Finch investigation stalled completely. Margaret refused to cooperate with investigators, and without her testimony or willingness to leave her husband, prosecutors determined they lacked sufficient evidence to proceed. The case was closed with a notation that the boarding house had ceased operations, though investigators suspected the couple simply relocated to a different mining camp. A third case surfaced in Yuba County. Thomas and Sarah Rowland operated a way station along the route to Downeyville. Multiple witnesses described Thomas arranging encounters between Sarah and male travelers. This operation appeared more sophisticated than either the Kephart or Finch establishments. Thomas maintained a regular clientele of merchants and freighters who planned their routes specifically to stop at the Rowland station. Sarah's participation seemed more ambiguous to investigators, with some witnesses suggesting she cooperated willingly, while others reported signs of coercion. The Rowland case never reached trial. Thomas died in a mining accident in October 1855, and Sarah disappeared immediately afterward. Investigators theorized she had family somewhere who took her in, but no records confirmed this possibility. El Dorado County revealed a fourth operation near Placerville. Here, the situation involved a younger woman, possibly still in her teens, married to a man twice her age. Neighbors had reported concerns to local authorities as early as 1854, but no action was taken until the statewide investigation brought renewed attention. By the time investigators arrived, the couple had abandoned their property and fled to parts unknown. Attorney General Hempstead's final report, submitted to the governor in December 1855, identified at least 7 credible reports of husbands profiting from wives in similar arrangements across the mining regions. The report acknowledged these represented only cases that came to official attention. The actual number likely exceeded this count significantly. What made the report historically significant was Hempstead's analysis of why such operations proliferated in the mining districts specifically. He identified several contributing factors: extreme gender imbalance in these regions, with men outnumbering women by ratios approaching 10 to 1, geographic isolation that limited legal oversight, economic desperation among failed prospectors seeking any income source, and cultural attitudes that viewed frontier California as exempt from conventional moral standards. More critically, Hempstead's report acknowledged the legal vacuum that enabled these situations. California statutes provided no clear prohibition against a husband's exploitation of his wife's labor, regardless of its nature. The marital relationship created legal privileges that shielded behavior which would have been prosecuted aggressively in other contexts. The report recommended legislative reforms, including expanded definitions of forced prostitution that would apply within marriage and enhanced legal standing for wives to testify against husbands in such cases. These recommendations went nowhere. The legislature declined to take up the proposals, with multiple assemblymen arguing that tampering with marital authority would undermine the foundation of social order. Private correspondence between county sheriffs, uncovered decades later, revealed a more cynical reality. Law enforcement officials throughout the mining districts understood that similar operations existed in their jurisdictions, but chose not to investigate. Some cited lack of resources. Others admitted they viewed the matter as too legally complicated to pursue. Several expressed the opinion that wives who remained with husbands under such circumstances must be complicit or willing participants. This willful blindness allowed the practice to continue. The Kevhart prosecution, rather than establishing precedent for aggressive enforcement, became an outlier. Other cases were ignored, dismissed, or quietly discouraged from reaching formal complaints. Eleanor's suffering, and that of women in comparable situations, was absorbed into the broader violence and exploitation that characterized frontier life. By the spring of 1856, newspapers had stopped mentioning the Kevhart case. The brief period of public attention dissolved into silence as California focused on other scandals and concerns. The case that had briefly ignited debate about marriage, exploitation, and women's legal status vanished from public discourse as though it had never occurred. Moral reform literature from the late 1850s occasionally referenced the case obliquely. A temperance pamphlet published in 1858 included a paragraph about degraded men in mining camps who treated their wives as chattel, likely alluding to Silas, though not naming him. A women's rights advocate writing in 1859 mentioned California cases where wives suffered abuse enabled by legal structures, but provided no specific details. These fragmentary references represented the entirety of the case's legacy in public memory. No legal reforms followed. No significant judicial precedents emerged. The Kevhart trial became a footnote in California legal history, occasionally cited by scholars examining 19th-century marriage law, but otherwise forgotten. Silas Kevhart himself did not disappear. Census records document his continued presence in Nevada County with uncomfortable clarity. The 1860 census listed him as a saloon operator in Grass Valley, living alone in rooms above his establishment. His occupation was recorded as legitimate business owner. The census taker noted no wife, no children, no family connections. City directory listings from the early 1860s show Kevhart's Saloon, and operating on Main Street, advertising itself as providing refreshments and entertainment for the discriminating gentleman. What entertainment meant remained undefined, but the phrasing suggested nothing had fundamentally changed about Silas's approach to commerce. He appeared in court records one additional time, in 1863, as defendant in a civil suit over unpaid liquor supplier debts. The case was settled out of court. No criminal charges ever touched him again. He lived another 17 years, dying in 1872 from pneumonia, according to his death certificate. His estate, valued at approximately $300, passed to a nephew in Pennsylvania. Eleanor Kephart left no such traces. Her fate remained unknown, despite extensive efforts by later researchers to locate her. The historical record preserved Silas's mundane details while erasing Eleanor completely, a pattern that reflected broader, systematic silencing of women's experiences in the 19th century. This erasure was not accidental. Women like Eleanor, whose stories involved sexual exploitation and social shame, were deliberately excluded from historical narratives. Their experiences challenged comfortable myths about frontier life and American progress. Acknowledging their suffering required confronting legal and social structures that most Americans preferred to celebrate rather than critique. The few primary sources that documented Eleanor's existence, the court records and witness testimonies, survived only because they concerned Silas's prosecution rather than her experience. Even these documents centered male perspectives. Thomas Griesby's observations. Fenton's medical assessment. Reverend Cunningham's moral outrage. Eleanor appeared in these accounts as object rather than subject, her voice absent even from records of her own exploitation. Modern researchers examining the case face the frustrating reality that Eleanor's interior life, her thoughts and feelings, her strategies for survival, remain inaccessible. The historical archive preserved the mechanism of her oppression while erasing her humanity. We know what was done to her, but almost nothing about who she was, beyond victim of circumstance and law. This systematic silencing extended beyond Eleanor to countless women in similar situations throughout the American West. Their stories exist only as fragments, glimpses in court records, or passing mentions in letters. The full scope of their suffering, their resistance, their survival strategies, their ultimate fates, were lost because the society that oppressed them saw no value in preserving their voices. The Kephart case stands as testimony to what frontier justice could accomplish, and where it failed absolutely. It revealed that even when exploitation became undeniable, even when witnesses testified and ministers protested, even when juries convicted, the legal system's response remained inadequate. Eleanor deserved protection the law could not or would not provide. Her disappearance from history represents not just one woman's tragedy, but the systematic failure to recognize wives as human beings with rights independent of their husband's authority. If this story disturbed you, understand that it should. These weren't just historical curiosities or distant tragedies. They were real people whose suffering was enabled by laws and attitudes that many found perfectly acceptable. Eleanor's voice was silenced in 1855, but we can refuse to let her story disappear entirely. Click the like button and subscribe to ensure these forgotten histories continue reaching people who need to understand how far we've come and how recently these injustices occurred. Share this video so Eleanor's story, and the stories of women like her, finally receive the attention they were denied in their own time.